Alex here with part 83 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I like to glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series has to do with giving my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We are moving into my application for a judgment on child support arrearages. I do have a lot to say on my mindset. Most of it's technical, though. I realized I could, at this point, try to get the district attorney's office to take over collection of my child support arrearages, but my opinion at the time, and I guess it's possibly today even, I'm not sure, and I don't want to put blame on the district attorney's office. I think that they just have a lot of cases. But anyway, my opinion at the time was that they take a long time to recover your child support. I imagined that it would take them several months, and mainly it's because I knew my ex would try to be difficult on purpose. But anyway, I imagined it would take them several months. I imagined that I would be able to do it a lot quicker. Keep in mind, I was working at a collection agency. I believe at this time I was, if not very shortly I would be. And so I learned how to execute on judgments on your own. And it was one of those things where after you do it like 10 or 20 times, and in this particular situation, it was at my job. After you do it enough times, it becomes almost as easy as mailing a letter. And the main reason is because once you get the judgment, the court isn't involved in collection anymore. And that's what was really appealing to me. I knew that I would need to get a judgment from the court, but that once I had it, I, on my own, would be able to execute on the judgment without disturbing my ex, her lawyer, or the court. So I imagined that this was the better approach, which was for me to collect my own child support arrearages. The other thing that I want to mention about my mindset was that I thought that my ex would realize that I knew how to do this, so she would pay her child support. You have to realize that my ex wasn't poor. At the time that we were in litigation, she was making at least 3 times what I was, triple what I was making, and she had a very, very stable job at the Veterans VA hospital. And so it wasn't a situation where I was concerned that she was suffering or that she couldn't pay. I knew she wasn't paying on purpose just because she didn't want to. She was capable of paying and she just didn't want to. And I think it was another way for her to trigger more litigation. And I think it was another way for her to undermine sort of the relationship. I know I should go into one last piece. There are some people that think, and I guess this is less people than there used to be. Now it's not so much, but I guess back then there were a lot of people who didn't like the idea of a father collecting child support. They felt that child support was something that was paid to mothers no matter what, and that was that. And there were even some judges and attorneys who felt this way. I was really trying to push the notion that child support was there to create a financial equilibrium between two households, which is how it works in joint physical custody situations. You have 2 parents with joint physical custody. You have a child who lives, for the most part, equal in both homes. And the purpose of the child support is supposed to sort of smooth that income over so that the other household can make sure that you don't have, I guess they call it rich parent, poor parent situation, where one parent is able to provide everything for the child and the other parent not so much. And it's not that child support makes it equal. It just sort of smooths the curve a little bit. That was my philosophical and ideological approach to why I aggressively pursued child support. The realistic and more, I guess you could say, realistic is the perfect word to describe it, is that I, at the time, was a part-time college student, and I did actually need the child support to make his life better. I was able to get a better apartment. I was able to make sure that he had all of the food and clothing that he needed. I was able to, and more importantly, I was able to pay for childcare because I had to work. That was one of the biggest costs that I had. And as far as food goes, food stamps were a big part of what helped out when I was 25, 26 and trying to get through college, and I couldn't really work full time. I was working between part-time and 3/4 time. It helped a lot. It made a big difference. And all of these things combined pushed me to try to collect child support against my ex. And there were, I don't want to say that there were times where I sought child support because of how difficult she was making the case, because that isn't necessarily true. But there were times, maybe it was just one time, possibly two times, where I did seek an increase in child support, not necessarily to get revenge on my ex, but because I had to go back to court anyway for other issues that she was causing. So I can't remember now the first time. We already went over it in the My Docket series, but there was a situation, I think it was withholding my visitation. Yeah, that's what it was. And I had to file a motion to hold her in contempt of court anyway. So we were already going back to court anyway. So I figured since we were going back to court anyway, I may as well set the child support at the correct amount. So that increased her child support from like $80 to $270, something like that. So, I mean, there is that sort of dynamic, but it isn't so much a revenge element as it is you're doing stuff that's requiring us to go back to court anyway, so I might as well do this too. And they were both resolved. Both issues were resolved at the same time. So that was an efficient way to deal with that type of problem. I think there's going to be a lot more to cover with regards to seizing your own child support monies, but I'm going to hold off on that until I actually get to some of the areas of the case where we go over my writs of execution and stuff like that. So I suppose at this point we can go ahead and take a look at what I have filed. Here we have my application for judgment on child support arrearages. I don't know why I called it an app. Actually, I do. I probably imagined that this was not a motion because it didn't require an opposition. And since it didn't require an opposition, I wanted to call it an application so that I can just ask the court to give me relief right now. There is logic behind why I did that, and it actually goes to a law in Nevada. So this wasn't a completely just out of the blue idea that I had. I felt that there was a law that supported me doing this. In hindsight, I suppose, no, actually, I think it was wrong. In hindsight, I should have filed a motion and I should have allowed my ex an opportunity to respond to the motion. However, the law still applies. It just doesn't apply the way that I imagined it did. Now, when I actually get to the citation of the law, I'm going to talk a little bit more about that. But for now, let's start with the introductory paragraph, which includes identifying myself as the petitioner, indicating to the court that I am representing myself by stating I am appearing in proper person, and that identifying the document that I am filing as an application for a judgment on child support arrearages. The motion, okay, yeah, we're moving into the points and authorities, specifically the factual background. And the first assertion is a summary assertion, which is that I and my ex share a common child of age 5, and that we separated in 2008. Next assertion is that the court awarded us physical and legal custody jointly. Next assertion is that the court entered its most recent order regarding child support, wherein my ex would pay me $73.91 per month, Exhibit 1. Next assertion is that my ex informed me of her unilateral decision to reduce her child support. I replied that my income has decreased and a modification requires consideration of both incomes, which is true. So she tried to say that she was going to reduce her own child support basically because she said so. And I'm trying to say that, hey, we actually need to go to court for that. The court has to consider more than just one change. So yes, maybe you had a certain thing that increased or decreased, but I and my income can also increase or decrease. And so this requires the court supervision. You can't just say, I'm reducing child support. Next assertion is that my ex falsely blamed me for the reduction in my income, and she sent a reduced child support check amount. I can't even remember her doing this. So guys, as I read this right now, this is a shock to me because I completely forgot that she did this. Next assertion is that I requested information on why she did not send any child support. So wait, what happened here? Okay, so in February, she sent a reduced check. And then in March, she didn't send anything. And then in April, I sent a letter. Okay, this is the law I was talking about. I sent a letter seeking enforcement of the child support order to my ex, and my ex failed to reply or schedule a hearing. I'm going to really enjoy talking about the statute when we actually get to it. And then the last assertion is that my ex just hasn't been paying any child support at all. Okay, so here we have my first, I guess this is legal analysis. Yeah, I guess this is the first issue, which is that due process has been satisfied by a specific statute, which is true. Here is a statute that I wanted to talk about. NRS 125B.140 subsection 2A. What's interesting is that this same approach is available to the district attorney's office, but in Nevada, we don't just have this as a power that's been conferred upon the district attorney only. We have this same power that's available to us as a parent. This is a complete shocker to me, and I imagine probably less than 1/10% of parents know that they can do this. I think most people think that the only way that you can enforce child support is by going through the district attorney's enforcement division. So I did some research, and I found out that there was a statutory scheme that mirrors the district attorney's statutory scheme. And the only difference between the scheme that I found and their scheme is that I, as an ordinary parent, can do the same thing. So I wanted to give it a shot and try it out. Spoiler alert, it worked. So anyway, this statute provides that before you can execute on enforcement for the support of your child, you have to do certain things. And these are the things that you have to do. The first thing that you have to do, or I guess you could say the only thing that you have to do, but it's broken down into 4 parts, is send a letter to your ex, certified mail, restricted delivery, with return receipt requested. All of these things are in the statute. You must comply with the statute for this to work. And this is what I did. So I sent my ex a letter, certified mail, restricted delivery, with return receipt. And the letter had to have 4 things within the letter. And I can't wait to show you guys the letter. I feel like this is the first time that I actually started to get my head around the law in my child custody case. I actually started to realize how much power a regular person has, not even being a lawyer, if they can just figure out how these statutes work. Okay, so the first subsection is that the name of the court has to be in the letter, and it has to have the order for support and the date of its issuance. The second requirement is that the letter has to specify the amount of arrearages accrued under the order. The third is that the letter has to state that the arrearages will be enforced as a judgment. And the fourth, and this is probably the most important, especially when it comes to why I filed this as an application and not a motion, the fourth has to explain to the responsible parent that they, within 20 days after the notice is sent, have to ask for a hearing. In other words, the obligation is on my ex to ask for a hearing if she's opposing the amount of the arrearages or anything like that. The onus is not on me. The onus is on her to challenge it, and she didn't do that. Ironically, I can't even say it was just her. It was her lawyer's fault too, because I sent this letter not to my ex, but I sent it to her lawyer because she's a represented party. So her lawyer ignored the letter. Anyway, we're going to get into that in a second. I attached the USPS return receipt indicating that my ex received the letter, thus satisfying the requirements of the aforementioned statute, and that it was my ex's obligation to ask the court for a hearing within 20 days, consistent with the law. And here's where I specifically state why I basically filed this as an application, not a motion. Therefore, an adverse motion is not appropriate, and the instant application should suffice. What I'm telling the court is, you don't need to hear anything from my ex, because she was the one that was supposed to ask for a hearing within that amount of time, and she didn't do it. Now, I want to clarify that I'm still wrong here. The reason I'm wrong, and the reason my ex should still have an opportunity to oppose, is because there's a possibility that something was procedurally incorrect. So yeah, what I'm saying here is true, that she had the obligation to send a letter or to ask for a hearing within 20 days. All of that is true. However, there are possibilities. Like, for example, I might have not complied with the statute. Maybe I didn't use return receipt. Maybe I didn't do restricted mail. Maybe the letter doesn't contain one of the required elements. All of these things are appropriate on opposition. These are challenges that my ex's attorney can make on filing an opposition to a motion. And so even though she can't really contest the fact that she owes money or the amount that she owes, she can contest all of the procedural requirements of the law. So, I mean, I kind of had the idea that she wasn't able to oppose, but I was only partially right there. She was able to oppose other things. She just wasn't able to oppose the fact that she owed money and how much money she owed. Okay, so I'm entitled to a judgment on arrearages. A judgment has not been determined and an order for support is in place pursuant to the law. And this law basically provides that if my ex owes money, the court shall enter a judgment. There is a discretionary piece here. This is the word may. And so it says that the court has the no, wait, hold on a second. Where am I looking here? After payment is due, such a judgment may not be... okay, so there's another section. The court, if the court... There's another piece of law that I want to talk about, but it's not cited here. So I might have to hold off and see if it comes up in opposition or on reply. So I'm not going to talk about it yet. I'm going to wait till it's cited. Same statute also bars the court from retroactively adjusting the arrearages owed to me. Correct. And the Nevada Supreme Court reinforces this in the decision Ramacciati v. Ramacciati. Let's see here. I am entitled to costs as well pursuant to a separate law, 18.160. And I am entitled to interest and penalties because of a third law, which is NRS 125B.140 subsection C. So I'm basically telling the court that I'm entitled to my arrearages, I'm entitled to my costs, and I'm entitled to interest and penalties. Okay, and then computation of interest. And here I'm citing the law that deals with the, what do they call it? Legal rate of interest. Anytime you are entitled to interest, but there isn't a contract that you've entered into with your opponent, then the interest that you're going to get is the interest allowed by law. And that's what these statutes are. NRS 99.040 subsection 1 controls the prime rate of interest and how legal interest is calculated. And then there's that other penalty statute, 125B.095, which adds 10% on top of the legal rate of interest, which brings me up to 15.25%. And then I go through the math of how much is owed. Conclusion. So my ex owes child support and she deliberately refuses to pay. I'm entitled to a judgment. Even if she were not paying due to hardship or inability, it is her duty to invoke NRS 21.112, which is true. So what I'm basically saying here is that my ex cannot get out of the judgment by claiming that she is unable to pay or that she's suffering a hardship. But there is other remedies available to her after the judgment is entered. And I just want to make sure that the court doesn't try and pull a fast one and say, hey, since she's not, able to pay or something like that, I'm not going to give you the judgment. You can't do that. You have to give me the judgment. There's nothing you can do about that, but you can allow her to, after the judgment is entered, try and seek exemptions. And I think I have a video on that. I think it's called Affidavit Claiming Exemptions. You can check out that video, but it basically tells you how a judgment debtor can protect some of their assets from being seized after the judgment has been entered based on their inability to pay. And it's more complicated than what I've just described, but there's a video dedicated to the topic, so I'm not going to talk about it anymore, at least not in this video. So I'm asking for a judgment on arrearages in the amount of $183.23, an award of interest 5.25 per annum, and penalties at 10% per annum. Now, the amount of child support I'm seeking to enforce is low, but keep in mind, if I want to sincerely tell my viewers, if I thought my ex couldn't pay, I wouldn't have done this. There would be no point in me trying to get a judgment that she cannot pay. Based on my communications with my ex, based on the fact that she was paid 3 times as much, based on all of these factors, came to the conclusion that she wasn't paying just to spite me. So I'm not thinking I'm just filing this to get my $125. I'm thinking that I'm trying to file this to let her know that I know how to do this. And hopefully because my thought was not that my ex was going to do the right thing just because it was the right thing to do. I had come to the conclusion by this point that she was only going to do something if she was forced to do it. In other words, if she couldn't get away with it. If she felt like she couldn't get away with something, then she would comply. And this is an extension of that sort of line of thinking. I'm thinking to myself, she's going to get worse unless she sees that I can handle this. And once she sees that I can handle it, she'll stop. That was what I thought would happen. And that's what happened most of the time in my case. Most of the time, when she realized she couldn't get away with something, she would stop. This time, it's a little murky. She kind of did, kind of didn't. We're going to talk a whole lot more about that as this issue continues to progress, because it is going to progress and it is going to evolve. Affirmation pursuant to the law. And that's just stating to the clerk of the court that this document doesn't contain a social security number. Declaration, which is my swearing under oath that all of the facts asserted are true under penalty of perjury. And then my certificate of Rule 5 service, which is just indicating that I served this document personally upon my ex's attorney by taking it and physically handing stacks of the paperwork over to whoever it was that was working behind the counter. List of exhibits. We have 5 different exhibits here, and we can go through some of them. It looks like one of them we've already gone over. And as we'll talk about that when I get into it. Here's exhibit 1. And here's the document that I've already gone over. And my standard policy in the My Docket series is when I find the document that I've already covered, I just skip over it. Anyone who's been watching the My Docket series in order would have already seen us go over the stipulation and order that's been attached as an exhibit here. And as with my previous videos, you can go down into the description below, find the link to the document, click it, download it, look at it for yourself. And if there's something in there that you want to talk about, just post it down in the comments below and we can talk about it that way. Another thing that I want to mention is later on towards, I don't know, maybe 2013, 2014, I stopped doing this. I stopped attaching orders as exhibits to other motions, and I would just refer to the motion or the order, whatever it was, and the date that it was filed. It was just a way to save paper. It was less clutter, and in my opinion, I don't really see any advantage to including it as an exhibit when it's already in the docket anyway, and you can just tell the judge where it is so that he can download it and read it for himself. Skipping, going into exhibit 2, and here we have an email. I guess we could start from the bottom as I've done before, because these go in reverse order. Okay, so still waiting on, this looks like my email to my ex. Still waiting on Army's eye doctor information. I'm curious about the dental care. When is the next appointment? Who's the new doctor? I noticed his 2 lower molars look like they're in bad shape. We need to get him some dental work soon. Okay, so guys, keep this in mind, because this is the first time I've seen anything like this in any of the filings, which means here we are in 2012, and the teeth problem has reared its ugly head. And just so all of you know, this is something that the court wasn't able to take care of until 2014. So the problem with his teeth, I brought to her attention in 2012, and she's going to lose custody of him over this in 2014. Next email is my ex saying his eye doctor, well, she's saying sarcastically that his eye doctor hasn't changed, and after his old dentist passed away, she hasn't found a good one. She's been calling around the last few weeks and thinks she may have found 2 options. She's stating that her healthcare went up to $5.24, blah, blah, blah. And so this is when, okay, so here she is reducing her child support. I wonder why her lawyer would allow her to do this. Her lawyer should know better. And her lawyer should be telling her, stop doing this. You can't reduce the child support like this. Moving on to the next one. I'm telling my ex that I don't have any eye doctor info, which is why you've been asked several times. Maybe you sent it, but how hard can it be to resend it if that's true? Anything else here about the child support? If the child support has been modified, so this is me stating here in the last paragraph that my income has lowered, so we need to look at recalculating child support. You can't just reduce it yourself. Lovely. So here's her response. So she's basically trying to turn the emails into litigation. She's trying to say that it's my fault that the income has decreased and that I'm choosing not to work full time. So this is not litigation. You can't litigate through email. Exhibit 3 here. And we have another email from me to my ex. I haven't received child support for March. Wondering if you're getting Army into soccer. So this is the problem with extracurriculars. And in fact, if you want to learn more about what my take is on extracurriculars, please watch my video on the topic. I go into it pretty thoroughly. So nothing here except for, hey, I haven't received child support for March. Exhibit 4. And here's me sending her attorney an email. Hey, I haven't heard from you regarding child support. This is a courtesy notice to inform you that I sent a demand letter to you, certified mail, restricted delivery in accordance with the law, and I attached a copy of the demand letter as a courtesy. But I didn't have to do that. In fact, compliance with the statute is based on the mail itself, not the email. And here is the letter that I sent to my ex. So here we go. I'm indicating that it's sent on April 12th, that it's being sent to our attorney, that it's specifically to enforce child support. And here is the letter notifying her that pursuant to the law, I intend to enforce the court's order that was entered on June 15th, 2011 by the Second Judicial District Court. So I'm complying with all of the provisions of the statute. The date the order was entered, where the order was entered, the fact that I'm intending to enforce the order, and the amount of child support that is owed per month. All of these things are required by the law. And then the next paragraph, I cover the payments that she's made, the amount that she's in arrears, which is 183.23 in arrears, and that it's her responsibility to ask for a hearing. Here I am stating it pursuant to law. You are required to ask for a hearing if you have a problem with these amounts. It's not my job to do that. It's your job. That's what the law states. That's what the letter states. That's what the law states that I have to put into the letter. All of these things have been complied with. And here is my proof. So we've got the sender info, the return receipts. I should see, here it is marked. Wait, where's the... There should be an indication that it's marked restricted somewhere. I don't know, I can't read it now. It might be this little X here. Certified mail. Oh, here it is, restricted. There's the X. Why does it say Exhibit 1? This is probably just a mistake. This is actually the next exhibit. It includes the proof of costs. Why is it doing that? Huh. This is probably attached to something else, and I'm including it because this is not Exhibit 1 or 2. We're still in Exhibit 5. Anyway, this is the cost. Here's the receipt. And here is the cost for me to print all that stuff up. Because these are all things that I can recover as costs. So I'm showing the court proof. Okay, Memorandum of Costs. And here I'm going over the postage, the copies, and the total. Oh, by the way, a Memorandum of Costs is it's basically a bill. You're trying to tell your opponent that you're going to be recovering these costs, and under Nevada law, if you have a problem with it, you have to challenge it within, I think, 2 days. It's real quick. And I think the court's supposed to set a hearing and what they call settle the costs. But my ex didn't challenge it. Here's another affirmation. Here's another Rule 5 service certificate. Here's 2 exhibits, receipt of postage and receipt of photocopies. Okay, guys, I know what happened now. So those last 2 exhibits that I was confused about in the previous document, those should have been included at the bottom of this document. I'm going to go ahead and fix that so that if anyone actually downloads these documents, they're going to come up correctly. But as far as this video, I'm just going to leave it the way it is. I'm not going to redo the video. Request for submission. So here I am submitting this application to the court immediately, and this is what I mentioned earlier I shouldn't have done. I should have just filed it as a normal motion, given her the normal amount of time to respond, and that's what I should have done. And I talk about the time to respond in the video, computation of time, so if you want to learn a little bit more about what I mean by that, just check out that video. Oh, also, I have a video dedicated to the request for submission. This is something that not every court uses, not even in Nevada. And if you want to learn more about when and why requests for submissions are needed, please watch the video titled Request for Submission. Here's another Rule 5 Certificate of Service. And I don't know if anybody's noticed, but at this point in time, I stopped filing those separate proof of services. I just include the certificate at the bottom of every filing. It's more efficient, uses less paper, there's less filings on the docket, it's just better overall. And it looks like I finally got a clue that this is the appropriate way, or the better way, I guess you could say, to do certificates of service, to just include them in the document that's being filed and not bother filing them as separate papers. And here we have the judge's immediate response, which is to strike my request for submission. So the court has reviewed my application, and the request for submission simultaneously filed May 10th, 2012, and orders as follows. He recognizes that we share a common child. This is his basic summary paragraph, that we share a common child, and he's going into some of the dates of these orders. For example, the court order that confers custody upon us, and then the court order that deals with, oh no, I thought he would also, or I guess he's going through both of those orders. He's going through the May 26th and October 19th order. And then he goes into, in the next paragraph, he goes into the order that deals with child support. And then in the next paragraph, he goes into my application. He's addressing the fact that my ex is trying to reduce her child support and not pay child support. He's also going into the law. He's recognizing that I claim I'm entitled to a judgment for arrearages. And he is going into the court rule, which is DCR 13, subsection 1, that allows my ex to file an opposition. And he's basically treating my application as an ex parte request, which is true. I mean, that's basically what I'm doing. And he is recognizing that I submitted the matter for consideration right now. And he is, let's see here, next assertion, he is, what? Request for judgment in this case is superfluous. Oh, he's so wrong about this. Okay, so he's stating that because the law provides that my stipulation in order counts as a judgment by operation of law, that I already have a judgment for which I can seek enforcement, but he's wrong. The clerk of the court will not allow enforcement unless they have what they call a judgment sum certain. Those are the two magic words. A judgment, quote, sum certain, unquote, has to be entered before a clerk will recognize and allow you to have writs of execution issued. So the judge is just flat wrong about this. I cannot file a writ of execution and refer to the stipulation and order that he is saying that I can. He obviously does not understand how collection on judgments works. Otherwise, he wouldn't be saying something so foolish. So I know that I eventually do get him to enter a judgment in the case. However, he, for whatever reason, doesn't do it at this time. Later on, I do get him to enter the judgment, and later on, I do get the clerk of the court to enforce that judgment. But this judge is flat wrong about this. You cannot just point to any random order on a docket and get a clerk to issue a writ of execution. They will not do that. Next paragraph is that I'm encouraged to seek the assistance of a licensed attorney in enforcing my order. That's nonsense. No attorney is going to charge me less than $500 to $1,000 in trying to enforce this. Seeking assistance of the Washoe County District Attorney's Office is a more appropriate request. However, at this time, I thought that that was an inefficient use of their time, and I thought that my ex would game that, because that's typically what she would do. She would game any government agency that was involved in the case. If you look at what she's doing with the Secretary of State, with the confidential address program, you can see where I'm going with this. And so I want to exercise my right to enforce the judgment on my own, and I will go ahead and do this, and I will succeed. Eventually, the judge realizes he's not going to be able to get rid of me, and he gives me what I want. Next paragraph is that I'm encouraged to seek the advice of a licensed attorney or visit the Family Law Center. I've visited the self-help center before, and they're not very good at helping with complex legal issues at all. I'm not going to talk about it too much in this video because I dedicated a topic to just the self-help center. Please watch my video on self-help centers if you want to know more about why my personal experience with them wasn't so good and why I don't honestly think that they're very good at helping people with complex legal issues. They are typically really good with helping people with very basic, simple legal issues. And we have the certificate of mailing, which is just indicating that the judge mailed this to me and that my ex's attorney was served through the electronic system. And I just want to mention that what the judge effectively did here was strike my request for submission. He didn't strike my application/motion. He just struck the request for submission to give my ex an opportunity to oppose and respond to my request for a judgment. Going into the aftermath, I filed 1, 2, 3 of those documents, but they were all free filings, so I incurred $0 in costs. Again, it's odd that I didn't include a motion opposition notice, but I guess because it was titled application, I didn't have to. Anyway, the reason I bring that up is because the motion opposition notice was the actual thing that went over the payment of costs. And in any event, I didn't have to pay any costs, so I incurred $0 in costs. My ex's attorney didn't file any of these documents, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent very little time reviewing the application, maybe 15 minutes max. She probably didn't think it would be taken seriously by the court, so she didn't want to spend much time on it. The memorandum of costs, I doubt she spent more than a minute on. The request for submission, another minute. So we have 2 minutes there. And then the order striking, I suppose she might have spent a little bit more time reviewing that and talking to my ex at least. So, I mean, we could make that 12 minutes to round that second chunk to a total of 15 more minutes, which combined with the first is going to come to 30 minutes. At the rate of $250 an hour, that's going to come to $125 in attorney fees for my ex. As for my previous videos, if you have any questions, feel free to post something down in the comments below, and I will see you guys next time.